To answer your question, Your Honor, I don't know about a Bay County form. Mr. Pumphrey can correct me if I'm wrong, but what happened is Ms. Peterson listened to the video of the jury selection proceeding, and she says in her report that at a certain point during Mr. Pumphrey's question, he specifically asked, have you or a family member, I'll quote here, has anybody here ever been the victim or had somebody in their family that was a victim of a crime? So it's a question asked by Mr. Pumphrey.
That's correct, Your Honor. And I had gone back after reviewing the defense motion and watched the voir dire myself, and that was the direct quote. That is correct.
Okay, so that was asked by Mr. Pumphrey.
It was, Your Honor, yes. So as far as the nephew goes, the defense has failed to meet prong 3 of the De La Rosa test. I will concede that that prong was met by Mr. Pumphrey as far as the issue of Juror Brown's wife's domestic violence case.
Right.
However, the defense fails to really get into the first prong of the materiality prong. Mr. Alperman talked about the materiality prong a little bit there, but he doesn't go far enough. If you look at some of the case law that I cited in my motion, specifically Johnson v. State, 6-3 Southern 3rd, 730, and 4
Hold on
Supreme
for
Court,
just a second.
2011.
I've switched off his motion and I'm looking at your response.
Yes, Your Honor.
Page,
Page 5 of my response, Your Honor.
hold on, page 5 of your response.
Yes, Your Honor.
Give me this.
The second paragraph where it starts when it comes to the first prong of the De La Rosa test. And I said Johnson v. State, 63 Southern 3rd, 730, Supreme Court, 2011. It goes on to talk about how there's no per se rule of form materiality, that the court can consider several factors, including the remoteness in time of the juror's prior exposure, the character extensiveness of that experience, and the juror's posture in the litigation. When you apply that to the information that the defense is complaining about, you're talking about prior exposure. This case that with the juror's wife happened 8 years before. The character extensiveness of the experience, this was a domestic battery case, and contrary to what Mr. Alperman said, this particular case with Mr. Crawford does not involve domestic violence. He was not charged with domestic violence, there were no allegations of domestic violence, and the juror's posture in the litigation, he was a witness. He wasn't the defendant, he wasn't the victim, he was just a witness.
Well, as I remember the trial, I don't think, I agree with you, it wasn't domestic violence, but wasn't the allegations that there were a brother of the, Mr. Crawford's client, the young lady, it was a domestic in that they were brothers and sisters, but not
Yes, sir.
more of a sexual battery.
But
Yeah.
it was, Your Honor, but Mr. Crawford, the case that Mr. Crawford was being tried for did not involve domestic violence. And the contention that the defense would have used a parental restraint in this particular case is disingenuous, because if you remember how the jury selection went, there were multiple potential jurors that would question the same question and talk about how they had family members who were victims of various issues, and the defense didn't use a single parental restraint on any of those jurors, regardless of what their answers were and what their experience was, what their family's experiences were with various crimes. And I would also point, Your Honor, to if I can find the page number to direct you to my response. The bottom of page 6, Your Honor, I want to point out a specific case where the 5th DCA in Summerlin v. State, 260 Southern 3rd, 1181, 5th DCA 2018. In that particular case, the defense asked for a juror interview, and the court would not allow the juror interview. And in that particular case, there was a juror who failed to disclose her own personal experience with sexual assault, and that was in a lewd or lascivious battery case. The juror's experience was directly related to the charges in that particular case, and the court still would not allow a juror interview. The nature of the allegations for this juror's wife's charge, or that she was a victim in, is even more attenuated to Mr. Crawford's charges. So I would ask that the court deny the defendant's motion. because the defense has failed to meet all three prongs of the judicial test. This is nothing more than a Hail Mary fishing expedition to overturn the jury's verdict in this case. And the U.S. Supreme Court and the Florida Supreme Court, as cited in my motion, has been very strict about when jurors can be interviewed and when you can inquire to the nature of discussions in the jury room.
You want to respond to that last case? That was pretty strong
Yes, Your Honor.
about the one that, had been a victim, didn't disclose that.
I'm ready to quote from it, Your Honor. I'm quoting from the case, Sonneman. In this case, the foreperson did not conceal information related to a direct question asked during the voir dire examination. In fact, neither the prosecutor nor defense counsel asked the panel if any of them had personally been sexually assaulted. For this reason, the trial court correctly denied the motion to interview the juror. Those aren't the facts of this case. That is very different than have you or a family member ever been the victim of a crime. And, I come back to, it's clear cut from the Westgate case that I gave you, Your Honor. Materiality means the omission of the information prevented defense counsel from making an informed judgment that likely would have led to a peremptory challenge. If they would have known, Mr. Crawford being an attorney himself and Mr. Pumphrey being one of the most experienced criminal defense lawyers that I've ever worked with, if they would have known this juror Brown was a victim, was a witness to and had a wife who was the victim of a domestic situation, when in this case, there's no other way from a loose, general broad standpoint, the underlying incident involving sexual activity between siblings is clearly a domestic situation. If they would have known that, they would have used a peremptory. Doesn't have to be a C.A.U.S. challenge, but they would have said that juror is just simply not the right fit for this case. We need to explore this further. We need to see why Juror Brown didn't, maybe Juror Brown, maybe it's a different Juror Brown, maybe Ms. Peterson has it wrong. We need to get to the bottom of that, but if it can be established through the interview that Juror Brown did in fact conceal this for whatever reason, intentionally or not, then the next question in the argument is, was Mr. Crawford denied a fair trial because they were denied the opportunity to make an informed judgment about that juror? And again, the James case couldn't be more clear. The question for the court right now is, have we made a prima facie showing that this is material and relevant? The other two, I think Mr. Sullivan conceded, we meet. So it's just prong one. But the only question for the juror interview is, have we made a prima facie showing? I submit under that very low burden we have.
Mr. Sullivan, they're basically not even arguing the other juror, and I don't think it's even close. I think you would concede it's just whether or not it's material. I don't see what the prejudice would be to the state to just, because the defendant's not in custody, he's still got all his conditions of his bond. It's a very limited scope. Hold on for just a second. It's going to be a very limited scope as to what we ask the juror, Mr. Upman, you understand that. It doesn't go all the way back in. It's only going to be on this one incident. Agree?
Yes, Your Honor.
All right, go ahead, Mr. Stout, and I'll give you the last word.
Your Honor, the question isn't whether it's prejudice to the state or not. The question is this worth violating the sanctity of the juror's deliberations and bringing the juror in? And the first half of my response deals with U.S. Supreme Court case law that deals with why the Florida Supreme Court and U.S. Supreme Court is very strict about allowing these types of inquiries. The sanctity of the juror deliberations in the jury room is a fundamental aspect of our criminal justice system. So I would agree that there isn't a whole lot of prejudice to the state, but that's not the issue. That's not why both the U.S. Supreme Court and the Supreme Court don't allow this.
I agree with you. I've been a judge for 22 years, never granted a motion like this. Now, I do have a case up in Walton County, I think Mr. Uppman's on that case, where another judge granted the motion for the juror interview, but that judge was covering a docket for me. So I've got that one. But this is the first time I've ever granted one. So I'm going to allow it. And with that being said, I'm not going to take up the motion for new trial because there's no sense. I think both the state and the defense concedes that the motion for new trial is based solely on this jury.
Wins or falls based on your ultimate ruling after we have the juror interview.
I mean, we're here for sentencing today. I don't know if y'all want to proceed with that or if you want. I'll let you be heard on that.
It's the jurisdiction issue, the problem, Your Honor. The pending,
Still,
if we get sentenced today, I have to file the notice of appeal, and then we're fighting back and forth with the first PCA about relinquishing jurisdiction. I think it's cleaner, again, because there is no prejudice to say Crawford's not in custody, he's not flight risk in any way. Well, I'll get this scheduled with your schedule ASAP, so I'm happy to work with Mr. Sullivan so we can propose the 2 or 3 questions that the court would ask of Juror Brown, and we can do it in chambers, whatever is the best way that'll protect the privacy of Juror Brown, and but then we'll prepare to make an argument based on whatever Juror Brown says in response to the questions.
how about if you do this? How about if you and Mr. Sullivan get together and you come up with the questions that you're going to ask?
Yes, Your Honor.
If you can't agree, you can submit questions and the court will decide whether or not they will be allowed.
Yes, Your Honor.
And it would be in camera. Agree, Mr. Sullivan?
Yes, Your Honor.
When you say in camera, so does that mean that we won't be present, it'll be just the
No, I don't mean that. I mean, your client and the state and the defense will be present, but it'll be closed to the public.
Yes, Your Honor, I agree.
And to protect the sanctity of the juror.
Yes.
And there would be, there was some scheduling snafus in Walton County, probably because of me, more, I'm not placing any blame on the state of defense up there about getting the prospective juror.
I know how to do it now, Your Honor.
You think you know how to do it?
I will submit an order that hopefully you will sign that once we pick a date for the juror to appear, and I will ask the Bay County Sheriff's Office to personally serve the juror with that order.
Do y'all have any problem with the juror being able to appear by Zoom?
I would
I've
rather.
got no objection.
I don't either, and I want to do the least amount to inconvenience the juror as possible.
I would rather the juror appear in person, Your Honor.
You didn't care about Mr. Sullivan appearing today.
That's
Look
different.
how nice he looks up there on the videos. I'm gonna allow that. I'll tell you what I'll do. We'll send it, and if there's any hardships for the juror.
I understand that.
Any problem with that, Mr. Sullivan?
No, Your Honor.
All right. Anything else to come forward?
No, Your Honor. I will get back to you next week with proposed questions that we've discussed, and we'll work with your JA to get a date.
And then what I would like to do is go ahead, since we're coming down to Bay County, no, that one's gonna be in camera, never mind. I was gonna say we would set everything, but we can go ahead and